Okay, it is week 6, and it's time for week 6 lecture. So I am providing you the information concerning week 6 lecture, and so I'm going to get right into sharing my screen. Okay, you can see, make sure that you use the rubrics and the information that I've provided to you by email earlier in the quarter. Also, this is week 6. We have 2 more lectures, week 8 and week 10, that we will be doing. And you will see that the links are at the bottom. At the end of today's lecture, I will include that as well. And then I will also email you a copy of it. So now let's get into the announcement. Okay. For this week, we're going to deal with unconstitutional seizure. And to prepare for that, you were to read Chapter 9 of the Constitutional Law, and in your book, Gideon's Trumpet, which is a very good book, Chapter 10 and Chapter 1. And then discussion post, when are you under arrest? The initial post was due Tuesday night, last night, 11:59 p.m. Central Standard Time. And then your reply post is due Saturday by 11:59 p.m. Central Standard Time. Then there is the written assignment relating to the Criminal Law Project Amendment Controversy, which is due this Sunday by 11:59 p.m. Central Standard Time. And then here's a reminder that we are to finish strong. That's what we encourage you to do. That's what I encourage you to do. And that's what the whole school encourages you to do. And then the adversity of springboard success, you know what that's all about as well. I shared that during the open house. So now let's take a look at our calendar, course calendar. And we are right here with our reading assignment, again repeating what I just gave you. Your initial post, when we're under arrest, our lecture taking place now, the reply post, and then your written assignment with all the parameters, and it tells you that it's 2 to 3 pages, APA citations and references, and then make sure that you run your papers through Grammarly, and make sure you have a cover sheet as well. Okay. So now let's take a look at the module. Last week was midterm week, and I've graded the papers for that already, including your exam. The discussion post, when are you under arrest? And it gives a scenario here, and you are to respond to that. You are to determine, do you think this person has been seized? Why or why not? And then the scenario further explain your thinking and illustrate when a seizure has occurred. Very important factor, and we're going to talk about that a little bit tonight, when seizure actually occurs. Excuse me. Oh, sorry. And then, of course, your course project, the amendment controversy. Submit a short paper that identifies a controversial issue relevant to the criminal justice field and relating to your various interpretations of your amendment that you chose earlier. And then eventually this will become part of your project completely. And so you're going to read through this material, and it tells you what to do. It says for your assignment here, you need only write a short paragraph or two, not more than one page, that identifies the controversial issue. So make sure you do that. Make sure you have a cover sheet. Again, you want to make sure that you have that. Now, I think I had in the calendar 2 to 3 pages. I meant to change that, so you don't worry about it. I will not grade you if it's under 2 pages. So let me make sure. I think it was on the calendar as 2 to 3 pages. Let me go back real quick. So here we go. It's due on the 12th. Yep. Yeah. So I want to okay, requires 1 to 2 paragraphs, but no more than 1 page. Okay, there we go. So I'm saving that. Okay, so now if you looked at the calendar, you'll see it's consistent with it. So, alrighty. So now let's go back to our week 6. We've checked the assignments. So let's take a look at the lesson content itself. We're going to deal with the issue again. That's the topic of an unconstitutional seizure. We're going to deal with the Fourth Amendment, which is a very important amendment. Well, they all are. But in case of criminal law, it is one of the most important ones, criminal justice, because we focus on that particular amendment quite frequently. And we're going to talk about that in just a few minutes. Again, these are the assignments that are due this week, a discussion post and a short written assignment concerning the amendment controversy for what you've chosen as an issue earlier in the quarter. Okay. So now we're going to go into the lecture itself. Conducting constitutional searches, and this is one of the tools that we lawyers rely on, particularly as defense attorneys, which I was for many years, pretty successful at it. And searches are very important, and if they're not conducted properly, then a sharp lawyer will file a motion to suppress and or a motion to dismiss the charges for failure of the officer or officers or law enforcement agencies to follow and protect the rights of the individual under the Fourth Amendment. In other words, if it's an unreasonable search and seizure that takes place, then there is a good chance that the evidence that will be seized will not be admissible, thus weakening the state's case, and in all likelihood, in many instances, ending the ability of them to further prosecute an individual. Now, be aware, I try to explain to law enforcement people and the public as well, that the Constitution is there for your protection, and law enforcement has to follow the guidelines of that in order to get a valid or proper arrest. It is a tool that law enforcement must understand and be able to follow. What I was about to say, and I'm going to say this before we get into the lecture, is that individuals who may commit an act and are even dead right caught in the situation, and very clear that they did whatever it is they're charged with. If there is a violation in the course of obtaining information that can result in a conviction, and that information is seized in violation of the Fourth Amendment, no matter how egregious the crime, that individual could be set free or walk. So that's something for you to think about. So the fundamental rules of search and seizure. First of all, a question is, can a store detective do that? Can a loss prevention person in a store or someone of that nature conduct a search under the Fourth Amendment? And the answer is no. There must be governmental action, and the individual who conducts the search has to be a law enforcement person in order to have the individual who brings the Fourth Amendment violation. That had to be that kind of a search. Now, there may be a question sometimes if a person is moonlighting and they conduct the search, is it a violation of the Fourth Amendment? I'd say yes and no. I've seen it go both ways. I believe it should be, because it's quite clear pretty much that even officers that are off duty are still officers for all practical purposes, and therefore they should be charged with conducting a governmental action even in their moonlighting job. On the other hand, if a retired officer does it, it's probably not, because they are no longer actively an officer as defined by saying that they're involved with governmental action. Number two, that the person that makes the challenge must have what we call standing. In other words, the individual must be a person who has exhibited actual expectation of privacy, and that expectation is one that society is prepared to recognize as reasonable. So there's a reasonable expectation of privacy that the individual must have. Often an implied grant that falls within the shadow of other specified rights, or the penumbra, as we call it, that fall into it. So individuals have an expectation of privacy when they perform and operate in various ways, such as, for example, going into the pockets of someone, or stopping them for something when they appear to be suspicious, but it's based on their race, their sex, their national origin, or it might be based upon what they're really wearing as opposed to what they're really doing. And so we might have some issues there that are of a constitutional nature, that may be some violations of the Fourth Amendment. Those are just some. We're going to get more into details in a minute, though. Excuse me. The scope of searches. Unrestrained searches, unrestrained general searches offend our sense of justice, and that's what I was just talking about a few minutes ago. All searches must be limited in scope. In other words, scope, so that the officer doesn't have carte blanche, and general searches are unconstitutional and never legal. The evidence is thrown out. I had a hunch, so I did this. I had a feeling, I did this. Those kinds of things. I observed, that's a different thing. I heard, that's that gets closer to it. But with the evidence now of a person, like something is in plain view or something like that, then the searches are different. So even with the issue of arrest warrants, which we talk about later. Now, searches with a warrant. All searches with a warrant must be based on probable cause. And probable cause is a level of determination within the mind of a reasonable officer, a reasonable person, that crime is taking place, that something is taking place, and that the individual is doing something in violation of a particular law. To obtain the warrant, the person or officer must provide an affidavit supported by oath and affirmation, stating the facts of what established probable cause, describing the place that needs to be searched in particular, and the person or things to be seized, so that the person doesn't have carte blanche. For example, I've seen search warrants issued where individuals are looking for a rifle, and they're looking for a rifle. They don't say gun or handgun, they say a rifle specifically. Then they have gone through drawers, that apparently can't hold the weapon, and those kinds of situations. I've seen situations where during the course of a search warrant, the police got so aggressive that they tore the place up when it wasn't necessary for that to be done. And particularly if there's a person, they have to be sure that that individual is that person, and not that they got somebody that looks like it. Let's say, for example, if a person has a twin, and the person appears to be the person to them because it looks like them, but they say, it's not me, I have a twin. And they may then ask for the individual to produce some ID, and if the name on there is different and it's not that person, then they seize that person. That's going to be a bad search. So these things are very important, and they're interpreted not broadly but narrowly and strictly by the judges or the magistrate. Here's an opinion or Supreme Court case from 1927. Here's what happened. The agent had a warrant for intoxicating liquor and the manufacturer. They noticed a ledger showing inventory of liquors, receipts, expenses, including gifts to police officers. So obviously this was during Prohibition, and other things relating to the business. So the question before the court that came up was, can the ledger be seized since it wasn't listed on the warrant? And the answer was yes, because the ledger was closely related to the business of the illegal business. In other words, they did have records and observed those things that related to the actual business. So the court says yes, very clearly, and it makes a whole lot of sense. If you said no, they had to go back and get a warrant for it, then there would be a problem, because what could happen is that the ledger could be destroyed. Let's go back. Okay, let's get into vehicle searches. Vehicle searches are very interesting because of the fact that they're mobile, they are moves. So here's a landmark case, New York versus Belton, B-L-T-O-N, from 1981, for the warrantless search of a vehicle, incident to an arrest. Now here's what happened. The court held that when an officer has made a lawful custodial arrest of the occupant of an automobile, he may search the passenger compartment. In other words, where the passengers themselves are. So that means, what does that mean? Is that the glove compartment? Yes. All throughout the whole, under the seats, between the seats, and the seats, the floor, and everything. They may also examine the contents of any containers found within the compartment. That's why people get arrested sometimes for open alcohol, or they get caught with drugs or something because it's found, it may fall out of the pocket on the seat. If the container is within the reach of the arrestee, so also will the containers within the reach be able to be searched during a vehicle stop. So that makes a whole lot of sense. It's common sense, as a matter of fact, that they don't have to have a warrant to stop that vehicle. They've stopped that vehicle on probable cause, and that vehicle has violated some kind of, even like a tail light or speeding or some kind of traffic violation, as simple as that, can result in a vehicle search. After you obtain a warrant, you've gone through the steps that we discussed earlier. It has to be timely, and no excessive force to execute the warrant. Remember, I talked about that a few minutes ago. Now, that means that it must be the force necessary to effectuate the warrant. But if the individual has a weapon, you have a right to use the force that is commensurate with protecting yourself and or others. You also can exercise the force that's necessary to protect the property as well. There is a limited authority, though, to keep the occupants of the premises during the search, rather, because you already been given what you can do earlier in the warrant that is issued by the magistrate. So you have to follow those steps. That is why when you're drafting an affidavit, try to make it as broadly as you possibly can to cover any possible contingencies that you might expect. Officers can only search the areas where they reasonably believe the specified item might be found. I said that earlier. If the warrant states only one specific item, once it is located, that's it. That's it. Unless there's something that's in plain view. But you can't continue to search again. Officers are often protected with what we call qualified immunity. The exemption of a public official from being sued civilly for actions performed during the course of their job, unless they violate a clearly established constitutional or statutory right. So in other words, if the officers do something in error, that's different from if they do something egregiously. I had an individual one time that I represented years ago. They were trying to execute a search warrant, and to intimidate the people that were there, they went on the mantelpiece and they took an urn of the remains of one of their family members, and says, if you don't let me do this, or whatever they wanted to do at that time, I'm going to pour this out. And they did. But there was civil suit filed that we hired someone to take care of, and the people won, because that was totally outside of the realm, and it was an excessive action, and it wasn't something that person was doing. All they were doing was trying to irritate the individual. So you have to be professional in terms of following what the warrant says. The government can also seize any contraband or other evidence of a crime found during a search with a warrant, even though it's not specified. So let's say, for example, but remember, if they find what they want first, then they can't go any further. But in the course of searching for it in the proper fashion, if they're looking for it and they find some contraband, then in that case, it could be. Now, I mentioned a rifle. Now, there were instances back in the days in my early practice when one of the weapons that was, and you don't hear it much now, was a sawed-off shotgun. And they would go in drawers and find other things in the process of looking for the sawed-off shotgun, and that would be contraband. So that is something that could be seized, and then the individual has, or individuals who have control of that area, or a lot of times the residents and visitors are then charged in a situation like that. The contraband does not need to be described in the warrant. That's my point. Or be related to the crime. And that's why I was talking about such as the plain view doctrine, because it comes into plain view by the execution of the warrant itself. There are administrative warrants, civil inspection of private property to determine whether or not someone is complying with a rule or regulation or city ordinance, such as fire codes. Let's say, for example, if the code says you're supposed to have so many smoke detectors or O2 sensors, or for carbon monoxide in the place, they can check to see if you are in compliance. These can also be obtained so government agents can conduct routine inspections when occupants refuse their entry as well. The case of United States versus Biswell, facts are police visited the individual who was operating a pawn shop and was federally licensed to deal in sporting weapons. The police identified themselves, inspected his books, and requested entry into a locked gun storeroom. Biswell asked whether the agents had a search warrant, and the principal investigator responded that they did not, but that Section 923 of the Gun Control Act of 1968 authorized such inspections without a search warrant. There the agents found and seized 2 sawed-off shotguns. Remember, I told you about that earlier. Biswell was not licensed to possess sawed-off shotguns because he was licensed to deal in sporting weapons. And sawed-off shotguns are not sporting weapons. Question is, did the warrantless search violate the Fourth Amendment? The answer was no. Inspections pertaining to the sale of illegal firearms are justified, and that limited threats, such as this inspection to the gun dealer's expectation of privacy, are reasonable. He had no reasonable expectation of privacy because if he was not in compliance with what he was supposed to be doing, sporting weapons, and then had that, so the search was valid without a warrant. Search without a warrant. There's particular guidelines, exceptions, and we're going to hit those in just a second. Refers to a warrant. Fourth Amendment refers to a warrant because it requires judicial review of the government action before it takes place. The Supreme Court, though, has given some searches that are what we call exceptions to the warrant that are reasonable under the application of the Fourth Amendment, such as you give consent. Now, consent has to be what it is. Gun at head, force somebody, and they say, okay, then that's not consent. If you state something that's not a consequence, then you can't give consent. You think about it. Consent has to be a willful action that's not based on any type of coercion or any of those kinds of things. Frisk. Well, the Terry stop, that means you can pat down the individual, and if you feel bulky items, you can ask them to remove those things, and or you can reach in to them. Plain feel, that same thing is almost, and then plain view operates the same way. Incident to an arrest. So if you're in the process of making an arrest or executing an arrest warrant, then you find that there's something that you seize that is within the vicinity of that individual, then you can seize that without getting a warrant in particular. Automobile exception, we talked about that a few minutes ago. Exigent circumstances. You're chasing someone and a person runs into an area, a house, or even goes across a state line, leaves your jurisdiction, leaves your city and your local police, then you can still chase behind them, continue your search under the exigent circumstances because of the fact that you were in pursuit and or that person is trying, maybe if you are not able to pursue them, they're trying to destroy some evidence like drugs or something, or hide a gun or anything, those kind of things. So exigent circumstances, and exigent means it's imminent, or it's an emergency type situation. Open fields, these are areas where it's almost like plain view, but you can check those areas without a warrant. Property that's abandoned because no one really owns it, and public places, of course, that makes sense too as well. Searches with consent. Now, I talked about that a minute, but if an individual gives voluntary consent for the police to search, the police don't need a warrant. Any evidence found is admissible. The person may revoke the consent at any time. So let's say, for example, they start to give consent, then they change their mind. Only the person whose constitutional rights might be threatened by a search can give consent, not someone else. There's been cases that argue, can a roommate in a situation when the person that they're looking for gives consent, and those cases have gone various ways. There's a court case, which I'm drawing a blank on, that's a leading case dealing with that issue. But the general rule is that the individual who is being pursued has the right to give the consent. The Fourth Amendment rights are specified to the person and may not be raised on behalf of someone else or in some abstract theoretical way. This gets into what we call standing. And then consent to search an individual must be given by that individual, back to kind of like what we said already. Only the person whose constitutional rights might be threatened by a search can give consent. And this is saying that consent to search an individual must be given by that individual. Here's a case, the Matlock case, the home that a suspect was leasing, searched by the police, obtaining consent to enter the home from somebody who lived with the suspect. That's the case. This is the case I was talking about. And the Matlock case, so the issue was the consent valid on the Fourth Amendment? So the Supreme Court said in '74, yes. The court observed that recent decisions clearly indicate that the consent of one who possesses common authority over the premises or effects is valid as against the absent, unconsenting person with whom that authority is shared. Now, let's say, for example, though, if that person is renting a room and they have their own room and that room is locked and that, they want to check that particular room, that might be a problematic issue when it comes to Matlock. But if the place is, the entire, like this apartment that, you find yourself in living, or your condominium or something like that, then in that situation, then Matlock would apply. So someone else can give consent. Searches with consent, example of instances when individuals can't give valid consent. Landlord-tenant. Even though the landlord is the legal owner, they lack the authority to offer consent to search a tenant's premises or seizure of the tenant's property. And that's because there's an expectation of privacy by that tenant. Hotel employee, hotel guest. Supreme Court extended the principles to hotel employees as well. Same situation. Only the tenant or hotel guest can give consent, because again, there is a reasonable expectation of privacy that goes with that. Frisk, formed under the Terry versus Ohio. If an officer suspects a person is armed and dangerous, a frisk may be conducted without a warrant. Now, remember this: the frisk is not for obtaining evidence like drugs or things like that. It's to determine if a person has a weapon, because it's for the protection of the individual conducting the search. A frisk is authorized by the circumstances of an investigative stop. Only a limited pat-down of the detainee's outer clothing for the officer's safety is authorized, and that's what I was saying. Factors contributing to the decision to frisk include suspect that flees, a bulge in the pocket on the clothing, suspect's hands concealed in a pocket, being in a known high crime area, and the suspect crime would likely involve a weapon. Those are all safety factors if you think about it, and that is how a frisk applies. Minnesota versus Dickerson. I don't think I skipped one. No, I did not. Minnesota versus Dickerson. The officer conducted a frisk. The search revealed no weapons, but the officer felt a small lump in the respondent's jacket pocket. He believed it to be a lump of crack cocaine, and upon examining it with his fingers, and then reached into the pocket and retrieved a small bag of cocaine. Was the seizure warrant lawful without a warrant? The answer was yes. So wait a minute. Here's the rationale. As long as narcotics are instantly recognizable by plain feel or plain touch, because it was a rock. Crack cocaine generally is a rock. As long as the narcotics are instantly recognized by plain feel or plain touch, ultimately in the course of a lawful frisk for weapons, the officer feels something that training and experience that they've had cause them to believe is contraband, then there is probable cause to expand the search and seize the object. That's the Dickerson case. Some people don't agree with that case, and a lot of us defense attorneys did not, but that is the law, and that fits within an exception there. The plain view evidence. What is plain view? It means what it says. That unconcealed evidence that officers see while engaging in a lawful activity, which has to be a lawful activity, can be seized and is admissible. For example, if a government official is invited into someone's home and they see drugs on the table, there we go. That's a classic example. Technology is impacting the Fourth Amendment case law. There's a whole lot of things that technology allows that we didn't have before. Thermal imaging devices are used to be able to conduct plain view searches because they're within the view in those situations. Here's a case in 2001, Kylo, a search warrant needed for police to scan a home from the street and compare that infringed image to other buildings. The action is considered a search under the Fourth Amendment and requires a warrant because you're invading the privacy of that individual. So that's a different scenario. That's why sometimes people who eavesdrop from the outside listening to you in your house is a wiretap, must get judicial consent before that. because it would be a violation of the Fourth Amendment. Search incident to a lawful arrest. Once a person has been taken into custody by the police, and the question is, how do you know when you're in custody? And I always simply remind my students that if you don't have the right to leave, then you are in custody. The law, you don't have to say you're under arrest. Just a simple question from the individual is to determine whether or not they can go. The U.S. law recognizes the necessity of permitting a complete search for two reasons: safety of the officer, we've covered that, and evidence and other contraband should be recovered. So otherwise it would be able to be destroyed. And then under the landmark case of Chamel versus California, a 1969 case, searches after an arrest have to be, as I said, immediate earlier, as warrants would, must be limited to the area within the person's wingspan, the area within a person's reach or immediate control, not another room. Shermer versus California in 66, absent exigent circumstances, and a search intrusive as drawing blood would not be permissible without a warrant. Absent exigent circumstances. So there has to be some exigent circumstances as to why that blood is drawn without a warrant. We just had an instance recently where a nurse was arrested by the police, and she was handled pretty rough, and it went viral. All the news media reported it, and she refused to allow she refused to carry out a blood draw because the person was not under arrest and the person didn't have a warrant. So, and it wasn't an exigent situation. So as a result of that, the police arrested her, and the police ended up either losing their job or being disciplined, and a civil suit ensued in which she recovered damages for that. Automobile exception. This exception states that if a governmental agency has probable cause to believe that the vehicle contains contraband, then no warrant is needed. And it's just what I said earlier, because cars are mobile. And in the time it would take to get a warrant, the driver of the car and contraband could be long gone and the evidence destroyed. Make a whole lot of sense. Carroll versus United States. This is a landmark case that we studied in constitutional law when I was in college and then later in the law school. And this was during the Prohibition. Officers saw Carroll, who was suspected of alcohol sales, driving on the highway. They gave chase, pulled them over, searched the car, and found illegal liquor. And at that time, the National Prohibition Act allowed warrantless searches of vehicles for alcohol. Was a warrant necessary? Of course, no. The vehicles are more than homes and justify different rules. They can be searched without a warrant, provided there is probable cause to believe that there were contents in the vehicle that violated the law, which that was correct, and then the vehicles would be gone before a search warrant could be obtained, as what I said earlier. For an officer to search a vehicle without a warrant, they must have probable cause to believe that the vehicle contains contraband or evidence, not just a hunch. That's the famous Carroll case. Exigent circumstances, elaborating on that, the courts have recognized that sometimes situations take place that require immediate action before evidence can be destroyed. These include danger or physical harm to the officer or others, danger or destruction of the evidence, such as driving while intoxicated, hot pursuit situations like I referred to earlier, where there's a chase in progress, individuals requiring rescuing or need to be rescued. Open fields, abandoned property, and public places. The courts have extended the plain view doctrine that anything held out to the public is not protected by the Fourth Amendment because there's no reasonable expectation of privacy. That's the key. So if it's a abandoned area, then it doesn't apply. Open fields holds that land beyond that normally associated with the use of that land is undeveloped and can be searched without a warrant because there's no expectation of privacy. In the landmark case of California versus Ciarollo, the police looked from the air into a suspect's backyard. Does not violate the Fourth because it is open to the public view from the air. You might have a fence around it, but above in the air, you can still find that it fits within the exception of public places. Border searches and seizures. Searches of persons, belongings, and vehicles at international borders are reasonable under the Fourth Amendment for obvious reason. The farther a person gets from the border, the more traditional search and seizure requirements come into play. So it has to be very close to the border. In the case of United States versus Montoya de Hernandez, routine searches at a U.S. international border require no objective justification, probable cause, or a warrant. Quinones Ruiz versus U.S. 1994 case, the border search exception applies equally to persons entering and exiting the country. Special needs searches. There are limited searches that the court says is reasonable because society needs outweigh the individual's expectation of privacy. So special needs does not mean something wrong with them. It means that the whole situation, such as a prison, a person who's on probation, and a parolee, drug testing for certain occupations, administrative searches of closely regulated businesses, community caretaking searches, and then public school searches. Now, public school searches of lockers and things like that, they don't have to have warrants, and they can be unannounced because it affects the place. Yeah, there may be some Fourth Amendment issues, but the courts will every time say no. The safety and welfare is more important than the individual's Fourth Amendment right, and it weighs heavier in that vein. So if you pay attention, prison, control, a person, parole and probation, that goes with the territory, drops or drug testing. I have had individuals that have lost jobs, such as correction officers, because they were subject to a surprise drop, and they, or either they knew it was coming and still were dirty and they lost their jobs. So it was a reasonable search, drawing blood and urine. Administrative searches of closely regulated businesses, as well as caretaking services. And then, of course, students should know this because all kinds of things are happening in the schools in our time now. Electronic surveillance, privacy interests, and the Fourth Amendment, and we're wrapping up here. Electronic eavesdropping, I kind of talked about this a minute ago. To searches of people's homes and luggage where they live, their bodies, homes, hotel, businesses, obtaining evidence from a person's body, such as urine testing or surgical removal of a bullet lodged within a person, are all cases that have been held to constitute searches under the Fourth Amendment. Physical presence is not required to constitute a search. In each case, the person has a reasonable expectation of privacy. As such, warrant is generally required. So you heard me talk about obtaining evidence from a person's body, such as blood or urine. The fact of the matter is that we're talking about, notice what it says, people, their luggage, where they live, their bodies, homes, and so forth. The point of the matter is that oftentimes in those situations you are made aware by rules or policy that you're subject to search. And by coming to those places, you waive your rights to a warrant or those kind of things. Otherwise, you stay away from it. And that's how they get around those kinds of things. Electronic surveillance, privacy interests continuing. The Omnibus Crime Control and Safety Street Act prohibits the interception of phone conversations unless one party to the conversation consents. Unless one party to the conversation. So is one of the parties the person who conducts the search and they're involved in the discussion? You can think about that yourself. I already know the answer. To obtain an electronic surveillance warrant or wiretap order, probable cause that a person is engaged in particular communications must be established by the court. So there must be a hearing, and the normal investigative procedures have to have already been tried. So the warrant for electronic, invasion of privacy, listening in, all other avenues have to be tapped. And if there's no other way to do it, then it's, these are usually taking place in instances that involve RICO, Racketeer and Organized Crime Act. And so Racketeer and Organization Crime Organization Act. And looking at organized crime, and oftentimes that's one of the issues that takes place that allow wiretaps, taps phones, bugs planted in the house, and things of that nature. So that's electronic is pretty big. The average person, average citizen, such as myself, the law enforcement cannot tap my conversations that are taking place in my house, even if they have the tools to do it without a warrant and probable cause established as to why they're doing it. Now, there's some issues under the Patriot Act that would have to be satisfied if I was a terrorist or a suspected terrorist, or, as I said, a member of a crime family in organized crime. That would be part of the basis, but they have to establish certain actions. Not that I'm a person who politically opposes or is a demonstrator or involved in protests and things of that nature. That's not adequate. There must be something beyond that as well. So that's about it. Very good Fourth Amendment chapter that we have here, and I think that all of the information that you need to make sure that you are satisfying the Fourth Amendment as a law enforcement officer has been given today. And as usual, if you have any questions or concerns, feel free to reach out to me. You know how to reach me. And I'm going to say good night. See you in week 8 when we have our next lecture.